I ended up moving it up.
All right, fellas, we are now live. Way to go, Idaho. Welcome. It is our monthly YouTube show. Work Comp Today. I'm Bernard Nomberg with brother David Nomberg, Nomberg Law Firm out of Birmingham. And our guest today is Joel Young out of Virginia with Reinhardt, Harper, and Davis. Gentlemen, how are y'all doing today? What's going on?
Doing well. Happy to be here. Thanks for inviting me.
Well, guys,
It's good to see you, Joel. Thanks for joining us.
Work Comp Today.
Good to see you as well.
We are very pleased that we're back. We haven't been here in a couple of months. Dave, I hope your summer's going well. You got anything new that is in your world to share with our vast audience before we jump into this month's articles and good stuff to talk about the law?
Yeah, the kids are back in school, and what's exciting is that the next time we do this, Alabama will have played about 3 or 4 football games, so we can talk about some Alabama football. So things are good.
I've heard they have a good program down there.
That's right.
Joel is our guest. You're learning very quickly. We do not stand on very much informalities. So before we jump into all the meat and potatoes of the monthly show, tell us a little bit about yourself and your practice, and then we will get after it.
Thanks, Bernard. My name is Joel Young. I am an attorney with Reinhardt, Harper, Davis. We have offices in Richmond and Fredericksburg. We also have an office presence in Charlottesville and Occoquan. We take cases statewide in Virginia from, automobile accidents. We do personal injury. I specialize in workers' compensation, but we have 7 attorneys in the firm, and we're able to cover the entire footprint of Virginia.
Very good. Well, that's the similar. We handle work comp and Social Security disability, a little personal injury, and we've got a bankruptcy specialist, Steve, who does such a fantastic job for us. And Joel, tell us a little bit about, let me scratch that and back up. Joel, what you may not know is the last 2+ years, almost 3 years, Dave and I have been doing this. We have colleagues from all over the country who come in and they're friends of ours, mainly through WILG, our national organization, but some are just colleagues, friends, and who do similar work. But we seem to have reoccurring themes. Of course, the pandemic has been a main theme over the last 1.5 to 2 years. Gig economy, Amazon usually finds its way in here, and things like that. And I guess where I'm going with this is, from your practice and your colleagues in your firm, do you specialize or focus on more types of work-related injury claims over others, like longshoremen or federal, or you name it? Is there a particular area that you guys seem to find to be known for doing more so than other kind of work?
Well, just to brag on the firm a little bit, we have 4 of the top 5 workers' compensation settlements that have been reported ever in Virginia. So the firm, certainly sees its share of catastrophic cases, sad cases, with significant, lifetime needs for somebody for medical treatment. In terms of how things work out here in Fredericksburg, there's an interstate called Interstate 95, and it's runs all the way up and down the eastern seaboard, and we see a lot of vehicle crashes that end up happening where somebody's driving a truck for work, and they have both a personal injury case and they have a workers' comp case. So we see a lot of those combined cases. We're still a heavily growing area here in the Fredericksburg area. We've got about 350,000 in kind of the metro area of Fredericksburg, Spotsylvania, Stafford, and that's growing. And so we've got a lot of construction going on. So we see a lot of construction injuries. We see obviously a lot of vehicle crashes. There are a number of distribution facilities for, say, CVS, Amazon, other and grocery stores. So we'll see a lot of box lifting. We'll see some of the machinery. Sometimes people get their hands caught in some of the machinery, especially where they're, have a glove that gets caught. Unfortunately, I've seen several of those. In terms of specializing, we're able to take on any case and pursue any case, but we see a lot of those cases.
Gotcha. Very good. Well, we will, as we thread through these articles, we'll come back to those issues and see if your firm handles those or how it impacts Virginia. So fellas, let's jump into our articles for this month. And the first one does come out of the state of Virginia. Workers' comp rates in Virginia could be headed down. And I don't think that's a bad thing. Joel, did you get into this article? What did you think about it?
Yeah, so I've seen the article and I've seen it reported different places. There are a couple different factors I think going on there. Probably the number one factor is back in 2018, Virginia adopted something called the medical fee schedule. So if you have a total knee replacement in Charlottesville, Virginia, that's going to be reimbursed, or the doctor is going to be reimbursed, and the hospital or facility is going to be reimbursed at a certain rate, and that's been set, and the doctors and the facilities know what that reimbursement rate is. That's going to be different than a Alexandria, Northern Virginia, Arlington total knee replacement. It's going to be slightly higher up in those areas, and that's all pursuant to the fee schedule. Used to be pre-2018 that a doctor in Northern Virginia may charge, double, triple what somebody else in a different area of the state may charge. And then there's a presumption that the charged fee is kind of the going rate, and then the burden's on the defense to show that it's not, and that promoted all kinds of litigation, of course. And the fee schedule really has limited any of that kind of litigation, and so I think the reduction in the amount that folks are paying for insurance, that's reflected in that I think lessening of litigation. Also, Virginia is a great state for business, and so that's certainly good for employers. I will say, if you kind of flip the coin over, the cynical side of me says, well, that probably means that fewer claims are being paid out. There was not a big COVID hit in terms of number of claims. People thought, oh, there are going to be all these claims. They're not. It's actually quite difficult to show for people who are not first responders. It's quite difficult to show that you actually contracted COVID through work. You basically have to be somebody who is a hermit, stays at home, goes to work, comes home. If you go to restaurants, if you go to bars, if you go to grocery stores, there's going to be probably a really difficult, you're going to have a difficult time proving that you got COVID at work. So
yeah, I think
all those things combined.
Joel, I think that at least from that standpoint, there's certainly no presumption in Alabama. And David, has there been any impact that you've read or know about work comp rates going down in our state?
I have not read anything recently in like what's going on with these Virginia rates. No, not.
Joel, one of the things that if you don't know by now, or you will over this next 45 minutes learn, Alabama does not set the trend on anything that helps injured workers in our state. We usually are last or next to last to make a decision to be beneficial toward them. So this is also our soapbox where we get to grouse about the crappy laws we have to deal with. So we'll move on from there. We're going to head out west to California. Yellowstone actress charged with workers' compensation insurance fraud. And Dave, I'll go to you first on this. We see this fraud issues become crimes. We've seen a lot of these coming out of Ohio and the Midwest. Anything of significance or of note about Miss Kilcher that you noticed collecting over 90,000 in disability benefits, even though she was working.
Yeah, I think this was a big story is because Miss Kilcher was working on Yellowstone, which has been a very popular show. Yeah, she was charged with workers' compensation fraud, meaning she was working, but while she was working, she was receiving temporary total disability benefits from work comp because she was saying, I'm injured on another job and I can't work. And so you cannot draw wages while you receive temporary total disability benefits at the same time. So, yeah.
And it's not as if she was in a type of job where she's not visible. If you're working on a movie set or TV show set, Joel, it's not like you're working in a back kitchen or in a non, I don't know what I'm trying to say, but other than, I don't know what she thought she could do to get away with this.
Yeah, the obviously this is an ongoing case. She's innocent until she's proven guilty, but the way it reads is she injured herself on the Dora movie, had a little bit of treatment, didn't do anything for a while, got on Yellowstone, worked there for a few months, and then immediately after Yellowstone gets to a doctor and says she hasn't been able to work this whole time. So I guess, I don't know how it works in California, but I guess the doctor signed off and she got a bunch, I assume, a bunch of back to wage benefits. It looks bad. And you're right. I mean, anybody who's paying attention, I assume, is going to figure something out. So evidently California's got things going so that they can figure this stuff out. I'm sure they're, Yellowstone reported wages, or she paid taxes or something. And there's some communication there between their system. And I guess California, yeah, it's an investigation by the California Department of Insurance. So
I'm wondering if this will result in any, not only restitute or fines, but I'm wondering if there's any potential jail sentence for her to set a precedent. But
we've covered work comp fraud in the past on this show.
Yeah.
And what we've learned over the years is that while individuals who claim that they're hurt and then they draw a TTD while still working, that exists, obviously. What we found is that when the business side, the employer side, the insurance side, when they commit work comp fraud, it just absolutely, the volume, the amount of money on that side of the fraud dwarfs the individual who commits work comp insurance fraud. You're talking hundreds of millions of dollars versus tens of thousands of dollars.
Yeah, because their rates are based on what their payrolls are. And if they're not reporting the payrolls, they're going to get hammered 10 ways from Sunday. Joel, let me ask you this little side issue here, not specifically related, but if you've got a hurt employee who gets hurt at job one in Virginia, and they have a second job, a weekend job, but they can't do that job either because job one injury is so debilitating, a surgery, whatever. Does job two wages or the impact that they can't work, or the fact that they can't work, does that impact the work comp case in any way?
Only if the employment is substantially similar. The example I give is somebody works at a deli counter, wears a hairnet, has the health codes they have to abide by, and basically serves people food. And that same person also works in a lunchroom at an elementary school, wears a hairnet, uses a deli slicer, has to serves people on a lunch line. Those are not considered substantially similar in Virginia. The cases where I have been able to stack those jobs, the wages for the jobs in order to get somebody an approximation of what they were actually making, combined with both jobs, involved a person who drove a dump truck, and there were essentially two different companies that were owned by the same people. They just happened to have two different sets of dump trucks. So on day A, he'd come in and he'd drive a truck for one company. On day B, he'd come in, he'd drive a truck for the other company. Same route, doing the exact same thing. In that case, they had it as two companies just for their own business purposes, but for the workers' comp purposes, they put them together and did give the guy his wage benefits based on both checks.
Okay, David, give Joel the sad reality about that same scenario in our beloved state.
Yeah, if they're drawing TTD benefits, they better not be working it for a different employer. They better not be drawing wages from any other source.
And does job number two impact the amount of TTD or the rate they get paid?
I may have answered the wrong question. So I thought you were asking, how does that second job impact it? And I answered it from the standpoint of, can you stack those wages?
Oh, no, you answered it correctly, Joel. Here's David's just telling you the sad reality of Alabama law.
Yeah, the second job does not apply as far as what goes into determining the average weekly wage. So if they've got three jobs, the only wages that matter are the wages that they were earning for the employer when they got hurt, not the other two employers. We can't bring those other employer wages into the average weekly wage.
Okay. So, and then I think you were maybe about to ask, well, if you're receiving a check on one, can you then work somewhere else? Well, let's say somebody has, let's say they're dissimilar employment. Okay, so in one, it's a physical job, gets injured there on restrictions of light duty. Let's say the second job is light duty. In that case, you could receive temporary total disability from the injury on the first job. You could still work at the light duty job because that's within your restrictions, up to the level that you were working in the weeks prior to really based on your average weekly wage at that other light duty job. You could continue to work at that level. If you exceed that level, then the insurer on the job where the person got hurt, they would get a credit based on however much you've exceeded those original wages from the light duty job.
Wow. Wish we had something more progressive, but we don't. But guys, I want to welcome anybody who's watching us live or maybe catch us on the replay. This is our monthly YouTube live show, Work Comp Today. I'm Bernard Nomberg with brother David Nomberg, Nomberg Law Firm out of Birmingham, Alabama. And our guest this month is Joel Young out of Virginia. And we're running through, as we do each month, cases and news and anything that really is of interest to our practices that deal with employers, employees, and independent contractors. And typically it's going to involve injuries on the job. It's typically going to involve overtime or whether they're being paid correctly. Whatever touches employment law, we try to bring it as news each month. And that's going to lead us to our fourth article. Fall protection lapses often result in poor planning. This is a report that was done. This is more of a national article. And I like these kind of articles because it really gives you a survey of things that are going on. And Joel, as you read through this, I hope you were reading through it with the bent or the thought of, how would this impact our practice in the state of Virginia and the laws? Did you take away anything here?
So I looked at this article from the standpoint of if somebody gets hurt and were there any fall protections, right? Were there some safety rules that were put in place for, not just the benefit of the workers, but also the employer? And then are those safety rules that have been enforced? Okay, so we unfortunately get the cases where maybe somebody has not been using that safety equipment, right? Or the safety equipment failed. And if they weren't using the safety equipment and it was a rule, then that changes the case for us. So obviously, I would love for everyone to be totally safe, and to have followed the precautions. I would like for the employers to make sure that the workers have a safe workplace. Obviously, we end up seeing those cases where somebody has gotten injured, and either there weren't those safeguards, or perhaps the client didn't follow all of those, and now we're involved. So I looked at it and thought about it. Okay, let's assume somebody gets hurt. Let's assume there are those safety, let's say a harness they were supposed to tie off or clip in. The way we handle those cases is the employer has to show safety rule violation, a written safety rule that had been enforced. And I have a case where a guy fell off a roof, and because of the layers of employers, well, we ended up taking depositions of everybody. And there's a roofing company where a guy goes and gets some other guys, and that guy is hired by, another company. And so there are all these layers of who really is responsible. Do they have a rule? How is it enforced? We ended up settling that case, but guy fell off a 2-story roof. It was bad injuries.
I was going to say that then maybe leads to third-party claims as well, which I know we always try to look for to see if there's any other avenues. But David, here's the shocking thing about this survey. It said almost 50% said that no fall protection was being used at all at that time. I mean, I know Joel and David, with our respective practices and as many cases we've looked at it with these type, you just shake your head. How can, and maybe it's cost cutting, maybe it's lack of personnel in place. We got to get the job done, even though we don't have it all properly planned out. But it's scary. Some of those, or a lot of those times, that over half or almost half have no protection at all.
Yeah. Well, and you got this mindset of, it won't happen to me. I'm fine. I'm invincible. Another interesting stat from this article was that employees were safer working for a general contractor than they were a subcontractor. So it sounds like the general contractors have more safety requirements. They're doing, they're having focuses on safety, requiring the harnesses, the tie-offs, whereas the subs, just get out there and work. So, subs were 2.7 times more likely to die from a fall compared to those that work for a general contractor.
Well, it's Joe, what percentage of your cases, if you were to have to put a percentage on it, historically have dealt with these types of fact patterns of falls?
Percentage wise, it's,
would it be in the top 5 fact scenarios that you deal with?
No, but it'd be in the top of the worst injuries.
Oh,
right?
definitely.
So in terms of number of cases, no, but in terms of severity of cases, yes.
Yeah.
I see more of guys falling off of ladders and shattering, both ankles. More so than the guy who's up on scaffolding and is not tied off. So it's more ladder use than anything.
Joe, it's interesting that you say that. One of the worst injury cases I ever had was at a new build residential many years ago, but the scaffolding that they put together was just hodgepodge. There was nothing signed off on it. They just used materials that were on the premise. and the guy basically fell about 35 feet because it was 3 or 4 story home, large home. Horrible double leg. Oh, it was horrible. But yeah, that's gravity gets you every time with those. Well, fellas, let's keep moving on to Ohio. No benefits. This is a good article. No benefits for worker injured in restaurant parking lot. And I know both of y'all have dealt with a scenario very similar to like this many times. Joel, I know we talked before going on the show. What was it about this article that resonated with your practice or your experiences?
Well, first of all, it's a social worker and a chaplain, right? I mean, it sounds like the start to a joke. So they just finished their morning visits with folks who are in hospice, right? Folks who are essentially have decided that they want to live in dignity, meet with the chaplain, meet with the social worker. But in terms of medical future, it's time. They have some time, and they're trying to kind of live with dignity for the last days of their life. So super important work that is, and these folks, they finish their morning appointments, and then on the way to the afternoon appointments, they stop at a restaurant, and guy slips and falls. The social worker slips and falls, and the looks like the court got into the factors of, okay, the employer didn't provide a formal lunch hour, didn't reimburse the lunch as a business expense. Luckily in Virginia on these facts, I believe we would get that covered. When the travel is for the benefit of the employer, that's one of the factors. And there's something called the personal comfort doctrine in Virginia. So, it brings into the course of the employment the injury. Now, Virginia has basically 2 tests. Did the injury happen in the course of the employment? That's basically, were you at work where you were supposed to be? And then did it arise out of the employment? So there has to be some risk associated with the employment itself. Now, if you don't know why you fell in the parking lot, you lose, even on these facts. The fact that there was ice means it arises out of the employment. So in Virginia, I believe this gets covered. As long as there was no frolic. Okay, so as the fact that they were going from morning appointments to afternoon appointments and the restaurant was on the way, also an important detail. If they drive out of their way to go to their favorite barbecue place, and that's where the accident happens, I don't think it gets covered.
Oh, David, if you're headed to your favorite barbecue place in Alabama, does this get covered?
Well, the good thing about barbecue in Alabama is I don't have to go far. So I'm probably not going to go on a detour. There's probably one right on my way. But, Joel's analysis was spot on. Yeah. And his analysis of Virginia law is very, very consistent with how I would analyze it through Alabama law. Arising out of and in the course of the employment, Joel mentioned the personal comfort doctrine, taking that a step further. Basically, if you're walking to the bathroom or you slip and fall in a bathroom while you're at work, or you're injured while at lunch on a smoke break, most of the time that is going to be compensable as long as the facts are there. I agree with Joel on his analysis.
Yeah, Joel, one of the things that you don't know about David just yet that you're about to learn, as I'm going to tell you, is he is absolutely telling you the truth. There are so many barbecue restaurants. No matter where he's going to any courthouse in our state, it is en route to the courthouse, a barbecue restaurant.
Fantastic.
Well,
I like the Alabama white sauce. I do.
Yeah.
We have a new best friend, David.
Yep.
I saved the best article really for last because to me, and I'm being facetious in that this is, Joel, our biggest hurdle for our firm's support staff when communicating with our clients about how they're supposed to communicate and deal with the medical personnel, the employer, their supervisor, whoever it is, about returning to work. And I think we could all agree that it is a very stressful time when our clients have been released by the physicians into whatever capacity, and it's now time to enter back into the workforce. So the article title, Relationship, Communication Key, Return to Work Success. And I'll start with you, Dave, for this one. And I don't know if we necessarily even have to dive much into this article. It's from your practice, your experience. Yeah. How difficult is it for your clients sometimes?
Is the lawyer for the injured worker, I'm trying to not be a hindrance when it comes to communication. I'm trying to facilitate communication, whether that's with my client or with work comp and getting that information from work comp to my client. And I will tell my clients, I'm not interfering in the employee-employer relationship, because most of the time I won't communicate with the employer, right? My communication is with work comp. And I use the adjuster to communicate with the employer about whether my client should be returning to work or not. Or I tell my client to contact his employer to find out if they need to return to work. So that's just a general rules that I follow here when it comes to communicating about the client returning to work.
Joel, what can you add about your practice?
Yeah, so I'll tell a little story here about a case that I had last year. A guy had cervical surgery, fusion, multi-level fusion, and he was sent to an IME, so he was sent to essentially a defense medical exam. The insurer sent him to the defense medical exam. That doctor said, oh, he can do at least light duty work. Based on a letter that the employer sent to my client, the insurance company filed, we call them in Virginia, an employer application for hearing. So my guy was already on a TTD award, receiving his wage benefits. That IME that said he could return to some duty, plus the quote offer letter from the employer, those two combined for the insurance company and their attorney to be able to file that employer's application, cutting off wage benefits pending a hearing. Okay. Problem with that letter is it essentially said, we understand you've been released by your doctor to modified duty work. We have work that's within your restrictions. Please plan on showing up on Tuesday the 16th and talk to Daryl, and Daryl will tell you what to do. Well, I told my client, not nearly enough information in the letter. Needs to be a bona fide offer, needs to tell you the hours, needs to tell you the wages, needs to specifically tell you what you're going to be doing. What do they have that is within those restrictions? None of that was there. So that, hilarity ensues, and we are in litigation for months and months and months and months, doctor depositions, IME depositions, and we won. We won all those back due wage benefits for those months and months and months, but it put my client through the ringer to have to wait on that. And it's all because they didn't tell him what he was going to be doing. I said, I'm not comfortable with you just showing up, not knowing what it's going to be. And we, ended up being successful. And now, we're case is set for mediation, and we're in a good spot in terms of where we are on the case. But that's an example, if you're an employer, of how not to go about it. And I deposed the employer. I said, where did you get the information? He said, well, I actually pulled the letter off of the internet. So, not the best cost-cutting measure for that particular case. So I like to, if the employer is represented, I'm talking to the board. I will send a letter to the employer if there's been some back and forth between the employer and my client about, oh, we may have something for you. I may send a letter saying, here are my client's restrictions. My client's ready, willing, and able to work. Please let us know if you have work within the restrictions. Please communicate with me in writing. so that there is not an allegation that my client has refused something, a verbal offer of work, because I've seen that too. And I've seen that come in cases where I've sent the letter and I'm able to hold up the letter and say, no, we set the ground rules early on. This is how the offer was to be communicated. It wasn't communicated this way. It doesn't count. So, but I want my clients to go back to work. I think my clients are better off so long as they're not hurting themselves when they are working. If they're sitting at home and thinking about their pain, that's worse for my client, right? My goal is not to maximize a settlement unless we have to, right? My goal is to maximize my client's life. And many times that's returning to work. It may not be for the pre-injury employer, but if they're able to get back there and find what the next thing is for them, that is progress in my mind.
Yeah, we preach that every day, because when a client is sitting home and not working and their mind is just running 100 miles an hour about their injuries, about their finances, about paying their bills, that doesn't do anything except send them in a mental spiral most of the time. So Joel, I think you're spot on again about that. And at least the approach that we have here at the firm, we want them back working as soon as it's practical, as soon as it's really feasible for them from a physical standpoint. But this article, David, I know could talk, and as well as you, Joel, could give seminars about this. But I wanted to just highlight it because the communication aspect is not, I think, communicated enough. You can't under communicate, or excuse me, you can't over communicate to your clients about how important it is to stay informed and to inform others, because that's going to draw the end of our articles for this month. But I don't want you to be sad, because we still have more of the episode to go. We've got to pivot now. And guys, I want to thank you if you're watching us live, or if you're just turning us in later when you watch on the replay. This is Work Comp Today. Dave, what's the other word, the other nickname you give for our monthly show?
Work comp nerds.
And he means that in the most loving way to our guests. But we talk about employer, employee, and independent contractor issues that our practices deal with and have for many, many years. And that's why we have Joel Young out of Virginia, Reinhardt, Harper, and Davis Law Practice. And they do a lot of awesome work in the state of Virginia, which has much better laws than ours in Alabama, but we'll move past that. But what I want to do now, Joel, is I want to do a little comparison. We've done a little bit as we talked about these articles, but we want to talk about the laws in comparison to Alabama with Virginia, maybe procedures, how things go. And the first thing I want to talk about, and we don't have to get too deep into this because we don't want to lose our 3 viewers. Dave, I want you to first talk about the role of a case nurse in the work comp process in Alabama. What's their purpose? What do they do?
So the case nurse or case manager is hired by work comp, and their job is to make sure that our clients are at their appointments. They coordinate between the doctors and make sure they're getting their appointments and facilitating all the medical treatment. That's probably the best definition of them. There's other definitions though. They are involved in the case for cost containment. And that is for money saving for work comp. And a lot of times these case nurses are acting as investigators for work comp and reporting back to work comp. What's interesting though, and where a lot of the reason I have issues with a lot of case nurses is that case nurse should be more aligned with our side and looking out for the best interests of our clients like we do as their lawyer. But so many forget what they're hired to do because they're paid by work comp and they work as an advocate for work comp. It's kind of, I've heard them called wolves in sheep's clothing. So I'll leave it at that and let Joel, I'd love to hear Joel's thoughts on case managers or case nurses.
Sure. So my mom's a nurse, retired nurse, taught nursing. And so I have, a heart for nurses and helping professions and healing professions. And so when I get a case and it really feels like the nurse case manager really is not focused on the injured worker, he or she's focused on, saving money, it just gets under my skin so much. And that can take many forms. Obviously, at my most cynical, it's not just cost containment, it's sabotage, right? And what does that look like? That looks like that nurse picking that client up and putting them with a different doctor that's that nurse's pet doctor, okay? Seen that happen many times. Now, usually that happens before I'm involved, because once I'm involved, we have more control. I've had a nurse case manager who we were trying to get my client back to the treating doctor, and she cancels that appointment, sends my client for physical therapy. And I filed for a protective order and filed for a show cause and filed to have her removed from the case. And I was successful. And if there's especially egregious action by the nurse case manager, you can file a complaint in Virginia, it's the Department of Health Professions, right? I mean, they still have certain professional requirements. And if they're not meeting them, they work for the insurance company, but they still have their license. And so now that's kind of a nuclear option in terms of is that going to help you in the case if the nurse case manager is still involved? Of course not. That's something that would happen after the case. But I have found the filing for a protective order to be, it gets everyone's attention. Nurse case managers in Virginia are not supposed to change appointments. They're not supposed to direct medical care. That's improper medical management. Now, as a practical matter, does it happen? Yes. Is it convenient for us? Yes, especially early on in a case where you have somebody who you have a level of trust with. But getting things authorized where the doctor is able to speak with the nurse case manager and say, this is what needs to happen. The nurse case manager usually has a direct line to the adjuster and can get things approved. Where those, and this is in obviously accepted cases from a medical standpoint. However, if Johnny, after 4 weeks of physical therapy isn't better, and the book says he should be, that's where I find that we find some friction. That if you're not healing like you're supposed to be healing, according to whatever schedule or book they have, that's when we run into issues.
I think we're in agreement that it's a very small percentage of those case nurses who are rogue. Most of them do awesome work.
Yeah, I agree with that.
All right, let's talk about returning to work a little bit more. Dave, I'll start with you. Do all of our clients return to work at some point during the representation?
No. What we see a lot of times is the authorized treating physician will say that our client is on light or restricted duty. And then the employer has to make a decision about whether they have a job for our client within those restrictions. Some employers can accommodate and our client will go back to work. Other employers do not have any type of modified duty and our client will stay home off of work and receive a TTD check. At the conclusion of their case, if they have permanent work restrictions and the employer cannot accommodate those work restrictions, then the employer does not have to bring them back. The employer doesn't have to find a job for them within those restrictions. So they may have worked their last day for that particular employer.
Joel, similar or dissimilar response for your situations?
Right. So what happens is in Virginia, if the pre-injury employer doesn't have work for somebody that has, say, light duty or modified duty restrictions, what will frequently happen is the insurance company is going to hire a Voc Rehab provider. And so Voc Rehab is where the insurance company is able to attempt to reduce the amount that they're paying in a weekly check to the claimant. There's a formula for how you decide what the remaining benefit will be once they find a job within the restrictions. It's 2/3 of the difference between what they made for their pre-injury wage and what they're making at that modified duty wage. But the Voc Rehab process can be challenging. They will send you a set of leads. You'll meet with the Voc Rehab provider initially, usually with me, unless it's started before I'm involved. And I'm trying to encourage both sides, if there are any issues, to talk to me. Let's figure this out so that we can move forward in the same direction. And sometimes the client is not super excited about doing Voc Rehab and says, get me out of this. Sometimes they do find, in today's economy, it's actually, they're finding jobs more than, say, 5 years ago, I've found. So, but my encouragement to my clients is help be part of that process. Yes, you have to comply. That's the bare minimum, but this is what's next for you. And the more you can be kind of in the lead for that, giving the Voc Rehab provider suggestions, tapping into your resources for places you want to work you want to do, the better off you're going to be for the next chapter of your life. So that's our system.
I don't want to get too depressed listening to how good the Voc Rehab and placement and all that is, but let's talk about our final topic, and this will probably be pretty quick. Joel, we're an at-will employment state. A lot of states are that way. If you're not in a union, you can be hired or fired at the will of the company for any reason, no reason, as long as it doesn't violate known laws. So if today is solid blue shirt day, Dave could get fired from his job.
Yeah, I don't like the look of that guy. Yeah, I don't think he needs to be back at work.
What about in Virginia? What is it, an at-will employment state?
Yeah, it's at-will employment. So I know we have a Willie listserv and we ask each other questions. Similarly, my firm is Reinhardt Harper Davis is very involved in our, especially workers' comp listservs. And there was a question today about, wait a second, there's this statute that says, if you get fired because you file a workers' compensation claim, they can't do that. But the key word there is solely. If you get fired solely for your workers' compensation claim. So, I don't like Dave's shirt. Oh, and so I'm firing him for that, and the fact that he filed a workers' compensation claim. I'm good in Virginia. So we don't see those kinds of cases where we're able to pursue that. It's an at-will employment state. They can fire you for any reason or no reason, as long as there's not the union component.
Dave, how tough are those retaliatory discharge lawsuits that fall under our workers' comp laws in Alabama? How tough are those to prove?
Yeah, to Joel, Alabama also has an anti-retaliation statute. And again, we use the word solely, just like Virginia. So we're at will employment state, and the termination has to be solely because the injured worker made a work comp claim. And that's a very high burden. That's a very high burden because usually the employer can find, as Joel said, that could be the shirt, or it could be some missed time from work, or some stolen time, or a little bit of property damage, just anything that takes it outside of the solely, takes it away from the solely standard.
99% of the cases along those lines we have to turn down, and it kills me, but it's just how the high burden is. Well, gentlemen, I want to thank you. We have reached and gone through all of this month's materials. Joel, thank you for joining us today. It's been a real pleasure.
This is fun. Let's do it tomorrow.
We will do it tomorrow, but we'll even have less viewers tomorrow than we do today. Dave, we've been doing this now since September of 19. We're coming on
Yeah.
3 years. This
For you
is one
guys.
of my
That's cool.
favorite monthly social media endeavors that we do, because we get to bring on a friend who does similar work that we do. We get to, as you said earlier, we get to nerd out a little bit about the work that we've been doing for so long. What is it that brings you to work every day other than to getting to see your big brother, have lunch every once in a while? What is it that brings you and keeps you motivated for representing folks who get hurt on the job?
I like helping injured workers. It's pretty much all I do now. My practice is very, very focused on that. And, you know, in Alabama, we have a complex set of workers' compensation laws. It's just not real easy for people who don't do what we do every day to understand that. So whether they may not like what I'm telling them, but I'm going to tell them what the laws are and help them navigate the workers' compensation system of Alabama. So yeah, I like coming to work just to help injured workers.
Joel, I put a link to your bio page in our show notes, and I want you to share, as we conclude here, your answer to that. What gets you motivated to come to work every day to do the kind of work that you've been doing so well for so long?
Well, I mean, I'll echo what Dave said. I like helping people. You're meeting people at this very difficult point in their life. They have very likely, found what their highest and best opportunity for work, and they're now injured potentially to a point where they're not going to go back to doing that. And it's our job. Not just to cushion the fall. We want to get them better. We want to get them back to work. That doesn't happen all the time. And so we're attorneys and counselors of all, right? So the counseling piece of that is, let's think about what's next for you. Let's try to help you through this. This is not about a big payday. There's not a pot of gold at the end of the rainbow. How can we help you move forward with your life? In navigating this complex system. And I mean, we've talked about all of these different laws, that law says this over here, law says this over there. How do they interact? That's difficult for lawyers. Workers' comp is difficult for lawyers. And it's obviously even more difficult for lay people. So I like helping people and being part of a solution, at least hopefully for this area of their life. People have lots of stuff that's going on, and especially through COVID, we've just seen so much. If we can help give them at least some understanding and some clarity, maybe not an immediate solution, but some understanding, some clarity of this part of their journey in their life, then I enjoy doing that every day, and helps me get up and get to work.
Gentlemen, I echo both of your sentiments. We take the emotion out of an extremely emotional time of their lives. We give them the information they need to have, not what they want to hear, but what they need to have to be able to move to the next phases. Joel, again, thank you for being with us for this hour. Dave, it's been a pleasure as always. We'll be back next month, 3 or 4 weeks from now, with our September episode of Work Comp Today. You guys take care, be safe, have a good rest of your summer.